What's up, everybody? Welcome back into another episode of The Lawyer You Know. And we are still talking Karen Read, trial number 2, even with a long break. And we're going to talk to attorney Melanie Little, who has been covering this case every second of every day, basically live streaming the entire court process, which it like blows my mind that you can sit there and watch a case on YouTube with a lawyer the entire time. But that's the age that we live in. And we're going to talk through what some of the issues are with this case, what the Commonwealth has done well, what the defense has done well, what we think some of the possible outcomes might be, depending on how jurors look at different presentation of evidence, and where we think of what the case is doing right now, right? The Commonwealth winding up their case. The defense is about to start their case in chief. What is that going to look like? What does the defense have to do to highlight reasonable doubt and potentially win this case? All that and more on today's episode. Let's get to it. So before we started, Melanie told me that she had started doing this YouTube stuff about 2 years ago. And I was like, well, you pick a heck of a time when this case is really exploding and the people are obsessed with it. And I know you have really dug in, not just following the trial, which I said, but also basically every single document, right? Every time I have somebody saying, Melanie Little said this about this document or whatever it may be, every document, every hearing, every second of the trial, what drew you to this Karen Read case?
Wow. I mean, where do we start? It's been so long that I've been covering it. I think, when I first heard about this case, and I heard, this girl backed up into her boyfriend and left him, and there's ring camera footage of the incident. I thought, oh, wow, that's terrible. It's caught on video. Like, slam dunk, she's guilty, right? And I think a lot of people thought that because that was the original story that was out in the media, is that they said they had ring camera footage of the incident. And I dug into it a little bit more. And, I have friends and family from that actual county in Massachusetts. And I'd been hearing for decades how corrupt the police department was in that particular area. And so it really drew me to the case. And then I started digging into all of the documents that I could find, every police report. There was a lot of information out there already by the time I started looking at this case in like January of 2024. And so that's what drew me to it initially. And then I found out there really didn't seem to be any ring camera footage. And so many things were sus. And the investigation was so wonky. And just so many things that are so interesting to us as lawyers. And like you, I'm a plaintiff's lawyer. So, we're in the business of injuries, right? I've handled thousands of car accident cases, thousands of assault cases, dog bite cases. And so the injuries were really the thing that stuck out to me from the beginning of this case.
Yeah, and just off a surface level glance of the injuries, they don't make sense. They don't look like a
No.
car accident. Then when you get beneath the surface level and you see no internal injuries, broken bones, even serious bruising, it's like feels impossible, especially if it was strong enough to, knock him flying back and land on his head. So I mean, the whole car accident element and a lot of these experts that we're hearing from and we're about to hear from, right? Because we haven't actually heard from any of the accident reconstructionists yet in trial number 2, but that's something that happens in basically not every trial, because some of the trials we have admitted liability and we're just talking damages. What we know who's going to win, just how much is kind of the question a lot of times. But so many accident reconstructionists that we've deposed over the years and had in trials. And when you compare that with Trooper Paul that we heard in the first case, that was kind of the moment for me. I knew nothing about this case going into trial 1, didn't look at a single document. This is the first case since I've been doing YouTube 4.5 years ish. This is the first case anybody ever warned me about.
Oh, really?
Yes, including like, I won't mention any names, but like big companies and corporations with streaming services that might be making videos and documentaries on this case. They reached out. They're like, would you want to be involved? But I do have to warn you about this case and where we think this might go. And guess what? They were all right, because this is as crazy as possible. But that first trial, I kept saying, let's wait. They're going to have an accident reconstructionist. Let's see what he has to say. And then they present Trooper Paul. So with your background dealing with car accidents, what was your thought when you heard Trooper Paul's testimony of how this was actually a car accident and not something else?
I kind of felt bad for him a little bit. I sort of felt like he was coming in there and he was going to be the hero of the whole trial. He's the guy who figured it all out. And they sort of gave him like a reverse equation and like, okay, here's the conclusion you need to come to. Now see what you can do to figure out how this might have possibly happened. And I think that he really thought that he figured it out and he did it. And he was going to And then he came in and it was just so embarrassing, I think, on so many levels. And I don't know, it was all we could do but laugh.
Mhm.
And, they're not calling him again. And you don't have to really wonder why, right? It just, none of it made sense. None of it
And
made sense.
that's the funny thing about people following the case on the outside and us doing this twice,
It's
is a lot of people were like, no, he was great. It made total sense. I totally knew where he was coming from. Like, yeah, I agree with him. It's like, no, you shouldn't. And the Commonwealth doesn't either. That's why they're not even calling him again. That's how bad he was as an accident reconstructionist. They went outside of the MSP, outside of the state to find some other accident reconstructionist that can do a better job, like a real accident reconstructionist. And that's the other thing I said a lot during the first trials. I'm sure you did too, is we call these witnesses, we know their backgrounds. When you read an ARCA resume, it's not like, oh my gosh, these guys are perfect. They could do no wrong. It's like, no, that's a normal, very good accident reconstructionist resume. This is what you expect, not Trooper Paul. And then when you compare the way they testified, that's why. And that's really the crux of this case is, did a collision even happen?
exactly. I mean, that's what I've been saying from the beginning. This is not, in New York, it's a PKD, it's pedestrian knockdown. That's what we
Yeah.
call it. I don't know what you
Yeah.
call it in Florida, but I have never, ever in my more than 30 years of practicing, handling thousands of these cases, seen a pedestrian accident with no bumper marks, no bruising below the waist, no knee, hip, foot injuries. I mean, it's just basic. It's common sense, really. There is no way that a human arm can shatter a polycarbonate taillight. There's just no way. And then for it to make it burst into 47 pieces and then just scratch the arm in perfect linear abrasions, it can't happen.
Yeah. I, I've had cases where, maybe it's a side swipe or somebody swipes somebody with a mirror and there's a scratch on their arm. Okay. Not this many scratches, not looking like this, first off. Okay. Definitely didn't shatter a tail light or shatter the mirror if it's just surface level scratches. Didn't even knock the person over, let alone knock them down hard enough to hit their head on the ground and die. So it's just like, if one thing is true, where a car could potentially scratch an arm, the rest of it's not true. If it's true that she's going 24 miles an hour hard enough to just cause this explosion of the taillight, then that's just not what the injuries would look like. And to me, that's one of the biggest hangups kind of throughout this trial. But something else that's extremely intriguing about this trial is the whole conspiracy cover up aspect of it.
Mhm.
And I know that, based on a lot of your videos and the clips that I've seen, and just even talking to you about it, obviously you think that she is not guilty at this point, and even probably innocent. If there's no car accident, then she didn't commit a
Right.
crime. What are your thoughts on the conspiracy? And specifically, I want to try to put out a little bit what we know, what we've covered, trial number one, and focus more on trial number two. Do you think the defense has highlighted, proven, at least spread the breadcrumbs that a conspiracy is a very real thing in this case?
I think that a lot of the witnesses that are testified in this trial have credibility issues. Right. I
Mhm.
think, when they're starting off the trial with this guy Nuttall, who apparently Hank Brennan wants to be the hero of this whole trial. That was his whole opening statement, was that this guy Nuttall heard the call of the bell and he's the hero. And then we find out that I think he says that he heard Karen say, I hit him, I hit him, I hit him. And they're kind of leaning on the confessions this time. But then when Katie McLaughlin testifies, we realize that he was inside the ambulance with the doors shut, so he couldn't have heard that. And then you have, Carrie Roberts testifying, and then it's brought out that she perhaps lied to the grand jury when she testified in front of the grand jury that she
Mhm.
heard Karen say to Jen McCabe, "Google hypothermia," and then she admits on the stand that that's not what she said, or that's not what she heard. She didn't actually hear Karen say that to Jen.
Right.
That's what Jen told her. So, and this is the basis of the indictment. This isn't the basis of the upgrade to murder too.
Yeah.
And then we find out that Jen McCabe is on the stand. Then we find out that Jen McCabe lied to the FBI. So it's almost like every witness that they're putting up has credibility issues. Then they're hiring outside witnesses, and then Shannon Burgess comes in and lies about his education. I mean, that, as you know, as a firm who I'm sure hires experts weekly at
Yeah.
least,
Oh, yeah.
that is huge. I don't think anybody realizes how huge that is. An expert to lie about their credentials. They're being hired because of their credentials and experience and education. And that was huge.
Yeah. Yeah. I mean, I definitely think a lot of the witnesses have credibility issues, but We've also had cases where witnesses have had credibility issues and the jury still believes them or is able to
Right.
kind of put them aside, especially if it's dealing with data versus, lying about your medical degree. Probably a bigger deal than what Shannon Burgess did. Obviously,
Right.
a huge deal. And for people like us looking at it, we're like, how could you ever do that? It's more embarrassing for Hank Brennan probably than anybody because it's like, you knew because you didn't even ask him about his education. And the first thing you asked Mr. Yale summa cum laude medical school is about his education. And so that's all very obvious to me. But I do think that some of the data, there's probably going to be some jurors that are like, okay, this is starting to line up with at least a timeline 1231, 1232. Is there a backup event? And John O'Keefe's phone stops working at 1232. So do you think at least the Commonwealth is starting to build a timeline of if they can tie it all together with Welcher, that there might be a timeline that would fit John O'Keefe or the Lexus went backwards at 1231/1232, hits John O'Keefe. He's incapacitated, never uses his phone again, and Karen Reed goes home to his house.
If Karen Reed was driving Chitty Chitty Bang Bang, yeah, maybe, because she could fly home in 4 minutes and connect to the Wi-Fi at One Meadows at 1236. That's the problem that I have. And then the other problem is now they're pushing the timeline a little bit further. They're pushing it 30 seconds, into the future.
Later.
So now instead of 1231, I mean, it's so confusing for me. And
I
I've been doing
agree.
this for
I
so many
agree.
years.
It's definitely confusing.
How is the jury understanding this? You've got, so now it's kind of into the 1232 area. And Jen McCabe testified that it's a 10-minute ride from One Meadows to 34 Fairview. She testified to that in those conditions. So there's no way in my mind that she could make it back there by 1236.
Yeah, and especially when they already have testimony from herself and from the Lexus data that she was not driving fast that night, that she was actually driving slow or driving carefully or however you want to put it because she was drunk. I do think they proved she was drunk and driving and shouldn't have been driving
I think
personally.
she admitted to that.
I agree. And that's one of the big pieces of evidence in this case that didn't come out in the first trial is her own
Right.
admissions and her own statements that I do think could be hurting her with the jury potentially.
Agreed.
But you're 100% right that the 131, 132 is confusing. The 7-1-3 is so confusing, and
Mm-hmm.
Jackson's demonstrative clearing that up was so much better. But I do think that, and I've had prosecutors do this against me in cases where they are purposely vague, where it's like a crime that happened in the past, and they'll put like a 3-day block. It's like, happened over a 3-day block, judge. That's not specific enough. We need to know which day or which. And they're like, nope, that's specific enough. So sometimes prosecutors are purposely vague. We have heard from the prosecutors, the 1231, 1232. What's the big deal? About 1 minute. His phone stops working 1232 and some change. So it all lines up ish. And we hear her on the voicemail and in some of her statements. 1241, she's inside the garage. 1242, the Lexus shuts off. So maybe they're hoping the jury is just thinking 1232, she leaves. She gets home 9 to 10 minutes later. That makes sense. But like you said, there's that pesky 1236 that Garino already testified to. She
Mm-hmm.
connects to his Wi-Fi. So it's one of these things where I think the prosecutor's being intentionally vague. And I'm sure you watched some of the juror interviews from the first trial. Do you think the presentation is better or worse, trial 2 versus trial 1, knowing that jurors are going to just completely dismiss some of the defenses as distractors or whatever they said last time?
Mm-hmm. Well, that was that jury. Every jury is different, right? And they're
Oh,
saying
yeah.
that this jury is much younger than the first,
Mm-hmm.
which I think could play better for the defense. Like I think that Hank Brennan has a much more concise case this time. He has
Mm-hmm.
completely streamlined it. By this time, I went back and looked at the first trial. There were, I think, the defense did not start its case until day 29 of testimony.
Wow.
We just finished day 20. Day 21 is coming up on Tuesday because now they had this 5-day weird break that gives Welcher a whole extra 5 days to go over
Still not
whatever
enough
he's got
for
to
him.
go
Still
over.
not enough.
And I think he's the last witness for the Commonwealth. I think that's it.
That's what I'm hearing.
During the first trial, we heard from every single person that was at the waterfall that night. We have not heard from any of the McCabe's except for Jen. We have not heard from anybody else who was at the waterfall. We have not heard from anybody else who was inside 34 Fairview except for, I think, Sarah Levinson.
Mm-hmm.
And so is the jury really getting a grip on what actually happened that night? They haven't called Proctor, they haven't called Higgins, they haven't called all of these ghosts, and these antagonists in this story that they are not going to produce. And so if the defense calls them, they are going to be able to say, why didn't the Commonwealth call these people for you? Why didn't they put them on the stand to testify? They've been talking about them the entire trial. And what do you think is better, the mystery of the jury doesn't not knowing who these guys are, or the defense calling them in and putting them up on the stand? That's a game time decision, I think. What do you do in that situation? I don't know.
Yeah, I think it's definitely going to be a strategy play, and that's what lawyers do, right? We have to weigh
Yeah.
the risk and the reward of who we're going to call. I definitely think they're going to call some of them. Like I would for sure 100% call Proctor, but then once you start to get to Higgins, Albert, and everybody else, each one of
Mhm.
them has a risk and a reward. And do you leave it over there, like you said, as kind of like the boogeyman? Do you want to confirm that somebody is the boogeyman, which I think you can do with Proctor,
Mhm.
but let the jury wonder about others? I think they'll probably call some, but not all of those witnesses. I mean, they have not said they're going to have a 4-week case, right? I think they said a week and a
No.
half to 2 weeks is going to be the defense's case. And
Right.
then I think we know that the Commonwealth is going to have a larger rebuttal this time than maybe some people are expecting, because Welcher is going to be able to come back and basically testify a second time fully, which I think is crazy that the judge is going to
Yeah.
allow that. But there's just so much still that seems unanswered from the Commonwealth's case, that they are relying on Welcher, like you said with Trooper Paul last time, to be their hero, to prove to us that there was a car accident, because that's something that they've fallen woefully short on.
Right.
Additionally, with Lally, the first trial is he tried to deal with his issues before the defense got to them
Right.
and minimize them and say they were distractors. And again, just like you said, every jury is different. And even within that jury, some people did not think they were the distractors. Some people thought they were very important and other people didn't. So the fact that Brennan has just avoided or ignored a lot of these issues, how do you think that's going to play with the jury?
I think that they have to be confused. I mean, it's hard for us, having seen the entire first trial and knowing the whole story, to step outside of that and say, what are they seeing now, and does it make sense? Because
Mm-hmm.
if I try to limit myself to what he's tried to prove so far, it doesn't make sense to me. We still don't know really how John O'Keefe died, other than blunt force trauma and what now may not even be hypothermia. And maybe now those Wisniewski spots that Dr. Irene Scordi-Bello found were as a result of drinking. They might not have been a result of hypothermia.
Mm-hmm.
So they have not really had one medical witness yet to show us any injuries that were caused by a car accident.
Yeah,
So I don't know if they even are understanding the story, or what is supposed to have happened. I find Burgess's testimony very confusing with regard to the key cycles, because in trial one, Trooper Paul said 1164 was when he did the testing. So if you go back in key cycles, that puts 1162 in the driveway at Karen's parents' house. So now again, they're trying to reverse engineer a theory using that 1162 key cycle. But my understanding of the key cycles is there's no date and time associated with them. So by just trying to line that up with John O'Keefe's cell phone, that's how they're trying to prove that that key cycle happened on what Shannon Burgess says was the 30th of January, not the 29th. So
yeah, I agree that all of that is confusing to me, because if backing up is a triggering event, how do you not have a triggering event multiple times every single day? Like driving,
right.
that whole thing is kind of confusing to me. But I do think what the defense was picking and choosing fighting with did kind of leave the jury open to think that that timeline is within the minute accurate, which I think could be enough without all the other issues, right? And that's what I kind of said about the Shannon Burgess thing. What a colossal mistake and embarrassment and joke and crush to his credibility, that I think could have been a helpful witness to the Commonwealth without that. Because unless he, megabits, megabytes, and not knowing the 30th versus, but he even said exactly 24 hours wrong, meaning the 29th instead of the 30th. I do think they could have made some hay with that witness. And I think there are some jurors that might say, oh, it was a mistake, or he was pursuing. I think that people are too quick to think nobody will ever think that, or it's so obvious, or I can't believe anything he would ever say. And some people on Twitter and in our chats, I'm sure, are saying that, and I can understand. And I think there are jurors that will dismiss everything he said, but I don't think that's going to be everybody.
Right. And but every single thing, there's so much reasonable doubt, right? And I think that if the defense just hammers home on reasonable doubt, That's what really needs to happen this time. I don't think an hour is enough for closings. I think being limited to an hour last time was horrible. I mean, there was way too much testimony. There was 30 something days of testimony. You can't sum that up in an hour. But I just think that, yeah, are they showing a timeline? Yeah, I think there's some bare bones structure of a timeline there, but we still don't have any evidence of a car accident.
I agree.
Right?
That's the big thing that's missing because, like we said, timeline-ish. They've proven Karen Reed was driving the Lexus. John O'Keefe was in the front seat. The Lexus went to 34 Fairview after the waterfall at about this time. They will say they've proven he didn't come in the house because Jen McCabe said he didn't come in the house. They're obviously intimating other things. That a backup event happened at 12:31, 12:32. Again, the pesky 12:36. How does she get home? But I also think, as far as cause of death, I think that everybody's been pretty consistent that back of the head, skull fracture, brain injury is how he died. Now, how did he actually get there and get to the ground is still what remains to be seen. But if I'm trying to look at some facts that they have proven and what's kind of been consistent, because even the brain surgeon and the ME both agree that that could be from blunt force trauma, head hitting the frozen ground, or from a ledge or edge type of surface. But he hit his head. That's what killed him. And they both say hypothermic tendencies. We'll see what the defense experts say. But again, at this point, taking the case in the light most favorable to the state and to the Commonwealth, I should say, and what they have proven, I think they have checked some boxes, but they have not checked the box of has a collision occurred, which is a major element to all of these crimes. What do you think Dr. Welcher would have to do to make you he's not going to prove it to you, right? Because you think there's too much reasonable doubt at this point, and I get that. And to me, common sense says this wasn't a car accident, regardless of what some expert says. And we know lawyers love to say in closing argument, use your common sense. But what do you think he would have to do to at least prove to some jurors a collision occurred? What type of testimony do you think would help get him there?
He's going to have to prove that the injuries are related to a pedestrian strike. He's going to have to prove that a human arm can shatter a polycarbonate taillight, that event can cause those injuries to the arm without shattering the arm, without fracturing any of the bones in the arm, because their theory is 24 miles an hour. And then he's going to have to show that he was thrown into the lawn. We still don't even know how far from the street John O'Keefe's body was found, because no pictures were ever taken and no measurements were ever made. And there was never, we really still don't even really know where the body was. And that event caused massive head trauma that would incapacitate him immediately. I just don't see, I'm trying hard to,
and I get it.
You want me to do, and I'm trying so hard.
That I haven't heard and haven't really thought of as much, which is like, if he can prove, because here's the point, and I think this is good. I think this is a good thought exercise to do. If he can prove somehow that an arm can shatter the taillight without shattering the arm, without internal injuries to the arm, with that level of, if you want to call them surface level or just beneath surface level scratches, I agree with you. I think that would be good. I think that would be helpful to the Commonwealth. I think as we sit here, we don't think he's going to be able to do that. But if he does that, I think that would be helpful. I also think taking some measurements. John O'Keefe's arm is how long? He's 6'1". If it's bent up, where is this part? You know, how many feet off the ground is this? How many feet off the ground is the taillight? Does that match up? I think that would be helpful, because if his arm is by the back window of the car, that doesn't help them. If his arm is by the bottom part of the bumper, that doesn't help them. So do the measurement with the arm bent. And then how can a taillight scratch an arm while it's shattering at the same time? I think try to explain that. If you can explain that, great. I think that will be helpful. If clipping with, again, they've also, Brendan has made sure he's pointed out that bruise on John O'Keefe's knee. And he has said, clipped. Have you been clipped by a car? How does somebody who's clipped by a car going 24 miles an hour, also their body projectiles enough to end up at a different spot in the yard? These are all things that I think Welcher could prove with his knowledge and background in science and math and testing. Will he be able to prove it is a different question, but that's what I want to know, right? Like, what can he actually put together for this jury that would answer a lot of the questions that we have?
It would have to be something similar to Trooper Paul, but not as laughable, I would say. No pirouette, no, it would have to be something concrete. And I let's see what he's got. because now he's apparently going to be able to come back twice, which I completely disagree with that decision, to give them another bite of the apple. I also completely disagree with the decision of not allowing Michael Easter to testify, the procedural expert with regard to police procedures, because while she's allowing a robust cross-examination of the law enforcement witnesses, the very few that we've seen, they're never going to admit to doing a horrible investigation. They're not going to admit to not doing things by the book, because we've seen them try to create a chain of custody where none ever existed before. We have seen them make excuses for the weather and that we did the best we could. And, the solo cops, they've got an excuse for everything. And I think that it is not within the purview of a jury to know what proper police procedure is. And I think an expert for the defense could really help in that situation. We also haven't seen, the close familial ties the close ties between Proctor and all of the people in the house. I mean, we've heard it through other witnesses, but
somewhat, yeah.
I think that needs to be brought out a lot more, how improper this investigation was and how he should not have been conducting this investigation at all. And the fact that he was fired and his horrible text messages and the text messages of Matt McCabe, tell him the guy never went in the house. I don't know that have we heard those in this trial
I don't
yet?
think so. I don't think so, unless it came out with Jen McCabe.
Yeah.
I can't remember, but I think there are some reasons to call people like Matt McCabe for some of the text messages that he was involved in and the butt dials and things like that. But
Yeah.
as far as like the Commonwealth is basically done outside of that witness we just discussed, what he would have to say to kind of help us get there, or certain jurors that may have some of the same doubts. I think it's going to be difficult for him to get there. But then the defense has their entire opportunity to bring their case in chief. With Easter, I completely disagreed with Judge Cannoni's decision, but it's also kind of funny because she's like, police procedure will be obvious after we hear from the Commonwealth witnesses. And you're like, come on. So the cops are going to tell you how good of a job they did. But at the same time, she's kind of right. It's so embarrassingly bad that I feel like most jurors are like, yeah, that's not how it's supposed to be done. So maybe she's an evil genius out there saying like, I know exactly how this is going to help the defense. You guys just wait. You don't know how it's going to help the defense, but it does seem very obvious how bad this police procedure is. Especially when you hear from some of the crime scene techs that are removed, that don't know anybody, that don't have a dog in the fight. And they're like, oh yeah, we wear gloves, we separate it, we log it, we photograph it, we wear a mask, we make sure that when we pick each part, we're looking at it under a microscope and making sure somebody else is there with. It's like all this procedure that nobody boots on the ground decided to do, especially when it was an actual crime scene, which is just wild to me.
Yes, that's true. We did hear from the Bodie Labs people and, some other technicians that are very meticulous with their procedure and process and methodology.
And that's how it should be. And you also brought up a good point of them not calling certain witnesses, right? And everybody's talking about Proctor, Higgins, whatever, right? That's fine. They didn't call those witnesses. We get it. But the fact that they don't call Trooper Paul and they don't call Julie Nagel.
Yes.
And Julie Nagel, to me, was an incredibly important witness if you believe what she says and if you find her credible. If you're a prosecutor and you have the one person who says they saw a blob on the ground that you absolutely in the first trial wanted the jury to infer that that is John O'Keefe's body, there's no doubt about that. Yeah, she's drunk. Everybody's drunk. She says she sees the blob at the right time to where it couldn't have been a fight in the house and then he's dropped in the lawn, and you don't even call her?
Right.
That's wild to me, that you don't even believe your own witness. That's what you're saying. You don't even believe your own witness, Trooper Paul or Julie Nagel, the second time around because you didn't even call them.
Didn't they try and get that in through Sarah Levinson, that Julie said she saw something? And I can't recall if it was.
I don't think it came in, but you're right. It is hard to separate trial. I do not think the black blob from Julie Nagel came in. That would be pure hearsay. So I don't know why it would come in. They could just call Julie Nagel if they wanted to get it in.
Right. And also get the timeline of when her brother was there, because she had that screenshotted text message that Jen McCabe asked for. And I don't think that's come in about what time her brother said here and he was outside, because that plays into the whole Commonwealth's timeline of events.
Well, he said his testimony was like 12:25 and then he was gone by 12:30 or something, or Karen Reed was gone by 12. I don't remember, but his timeline did not match up. And everybody was like, oh, they're going to see the text message. It's close enough. And it's like, I don't think they've proven that. That's not evidence.
And the first time Lally called 11 witnesses who left and said, I think it was 11, and said that they did not see a body on the lawn.
which
And
was
he didn't
helpful
do
to the
that this
defense.
time.
Yeah.
Yeah.
Yeah, that's helpful to the defense. All these, anybody I ever talk to, a normal person who's not fully invested in this case, and you tell them that 10 people leave the house and don't see a body in the lawn. And I'm like, hey, your house with that small front yard, it's basically like that. It's not an acre of front yardage that, you might miss something like a 6'1", 200-pound guy just laying in the middle of the yard.
In enough snow to track a cat, by the way. I mean,
Right.
like it would have even been brighter because there's a little bit of snow, so there's white. Your headlights are shining. You would absolutely see it. And
I would
and
think so. I would
Nagel
think,
says that Ryan Nagel said that when they left, Karen was still there, right? Because he said they passed
yeah,
by and they saw her with the dome light on, and she was the only one in the car.
right.
I mean, it's also not great for the Commonwealth that they're not calling all the people who were in 34 Fairview to say that he never came in the house, because last time, again, they did that. So there were 10 more people aside from Jen McCabe who said he did not come in the house. Now, the only witness that he has saying he didn't come in the house is Jen McCabe.
Yeah, and I don't know that that's a strategic decision because I have felt like Hank Brennan has tried to get a fact into evidence one time. And once it's in, he doesn't feel the need to bring additional witnesses to testify to the same fact. Lally was the exact opposite. He'd call 20 witnesses for one fact. Now, did it drill that fact more into a jury's mind? Did it bore a jury? Did it annoy a jury? Did the defense, was the defense able to get, all these people to agree to unbelievable facts? The first trial, and did that create reasonable doubt? Only time will really tell with that. But the defense has said that they are going to have a much more robust case in chief this time. And when we think about that, we know they're going to call an ME. We know that they're going to call an accident reconstructionist, a Google search expert. We know they're going to call all of those witnesses. But do you think they call people from the waterfall, the McCabe's, Alberts, Higgins, Proctor, the snowplow driver? Do you think they call a lot of fact witnesses as well as their experts?
I think they should. I think they should. I think Lucky Lochran was a good witness. I mean, they used him last time. He's the plow driver who said he did not see the body and he went by there. To me, he was very credible. A lot of people on the other side say he hit a basketball hoop. He's not even, I don't know what that has to do with him not being credible, but I think he was a good witness. Also, Nicholas Barros, who I think his name is Barros, the Dighton police officer who said that he saw the taillight and it was cracked. It was not completely damaged. Why nobody ever took a picture of that taillight? Proctor and Buchanan went there to tow that car, convinced this was a car accident, and the very simple thing to do would have been to pull out the cell phone in their pocket and take a picture of that taillight, and nobody ever did that. So Barros would be a good witness for them. Matt McCabe and all the suspicious activity that went on that night, the butt dials, because you could just call Brian Albert up for that limited purpose about the butt dial issue, and just a very limited direct on all of the suspicious activity that went on that night to just throw a whole bunch more reasonable doubt at the jury. Like, if there was nothing to hide, why were all of these people doing such suspicious things? Why did Higgins testify that he didn't make any phone calls in the early morning hours of January 29th? And then we see him on the phone on video outside the Canton Sallyport or Canton PD with all of this missing video that never showed up until after the first trial. All of this suspicious activity to throw more reasonable doubt and add it to the fact that there's nothing, no injuries to line up with the pedestrian collision. And I think that they can win this case. I think that she can get an outright acquittal.
Yeah,
But
I think that whenever you're calling a bunch of prosecution witnesses like that, though, you have the points you want to get, and not every single one of them is going to be automatically deemed hostile just because they were a prosecution witness last time. Some, like Proctor, I think obviously would and should. But I do think you have to be careful because they will be able to clear up some things. Like, I think Higgins and Albert could probably do a good job. We were messing around at the waterfall. There was nothing nefarious there. Nobody cared if John O'Keefe came, whatever, what the vibe was inside the house. I think there's a way they could clear that up because, again, the jurors don't know these people. They're not going to think they're a menace to
right.
society and they're these horrible people in a cover up and a conspiracy. I think that was always going to be impossible for the defense to prove, partially because of the bad investigation. But so I think you do have to be careful about thinking that people are going to see it the way you may see it, the way people in the chat may see it, the way Karen Reed may see it. And instead, it may make them more likable, especially somebody like Brian Higgins, who I think has a bad vibe right now. Maybe he comes
Right.
and testifies and they're like, oh, this guy seems harmless. Like he didn't do that. What are they talking about? He doesn't seem to care about Karen Reed. He's not holding a grudge. He doesn't seem scared like he ended a man's life. Like I do think there is a risk of that and drilling in because Hank Brennan's going to be able to cross them. John O'Keefe never came in the house. Obviously, Higgins maybe described somebody that sounds like John O'Keefe came in the house.
Mm-hmm.
John O'Keefe didn't come in the house, never walked downstairs, never an issue with this, never an issue with that. Get all of that corroboration through every single one of these witnesses. You know these people. You didn't conspire with these people. You didn't plan evidence. You didn't cover anything up. You talked to the police. You gave them your phone. You did X, Y, and Z. He's going to be able to get a lot of that out with these witnesses that are friendly to the prosecution, that it really should be an individual risk reward assessment as the defense goes through who exactly they're going to
Right.
call.
Yeah, absolutely. And it's going to have to be a game time decision. I don't think that they've made that decision yet because Commonwealth's not done. I mean, I
Yeah,
think if they rest, I mean, I think there's enough that they're not going to get a directed verdict.
no
And
way.
knowing what we know about the judge, we know that that would never happen anyway. And so if the defense starts its case on Tuesday, which is quite possible, right? If the Commonwealth call, well, no, actually, Welcher could be at least a whole day,
I
right?
would say it's going to be multiple days. I think he's going to be multiple days.
Depending on what his report says, because we're not privy to his
True.
report. And now that he's, who knows how long that report is, and if he's got a PowerPoint, and he's going to have relied on Trooper Paul's report to some extent, though, don't you think? Do you
I
think
don't.
they didn't even give him Paul's report?
I wouldn't
Because
if I was the Commonwealth. I'd be like, just forget about this, or maybe tell him like read it and explain why it's wrong. I mean, it just is what it is. I think it's stupid if they don't just say, well, maybe Trooper Paul was right about certain things. His explanation as to why they happened was completely wrong. That's why I came in and reconstructed this. And here's what actually happened. And let me explain the things he couldn't explain, like how did his phone end up there? It just did. You know, those are, you got to have reasons for
right.
how this stuff is possible with the math and the science.
Yeah. I mean, there were some other things I noticed that I didn't notice at the first trial, like when they held up the jeans, that did you notice that the back pocket was ripped?
Mm-hmm.
Which to me indicates a sign of a struggle. Somebody grabbing him by the pocket, it could be somebody, a dog grabbing him by the,
I've got a pair of jeans with a ripped pocket that was already ripped before I put them on.
would
He
you
could have
wear
ripped the
them?
pocket if he was hit and he pirouetted and flew and it caught on something I mean, I've had clients with torn up clothes after they get hit and tumble in the street and dragged through whatever it may be, catching a rock. I mean, that's possible. Now they didn't only have a scratch on the arm.
Right, they had
They
some
were much
bruises to their
worse
body.
off. They were destroyed. They had
Right.
broke from collarbone to pelvis, 25 broken bones. Like that's what their body looked like. So I get it. It doesn't all fit together, but yeah, I mean, I think it's interesting. Nobody's mentioned it, right? I
Yeah,
mean, nobody really even mentioned it to the jury. Nobody highlighted that.
like the socks. The socks are interesting to me because we know that John O'Keefe kept a shoeless house. Because two witnesses have testified how you had to take off your shoes when you went into his house, or he would get mad.
Yep.
That indicates to me if he went in the house at 34 Fairview, he would have taken off his shoes out of courtesy because people do, right? It was snowing.
I would think.
There might have been dog hair on those socks. Those socks never made it into evidence.
Oh,
They were on his feet at the hospital. We saw pictures of them. It was just curious to me that they've never been brought up and they were never collected as evidence. So it's
That
just
is
one of
interesting,
those
especially
things
since
that
he
I'm
lost
like,
a shoe. Yeah.
yeah.
I never thought about that. That's interesting. Yeah. I don't know why. And again, once again, par for the course for this investigation, right?
And you don't know what the jury's thinking because maybe the jury's thinking that too. Like, where are the socks? Like, I would think something like that. So they're going to have a lot of unanswered questions, I think, at the end of the Commonwealth's case. And then they're going to wait and see if the defense can answer them. And then, I mean, they just really need to hammer home in closing. Listen, if you are sitting back there thinking of any other way that John O'Keefe could have been killed other than a car accident, that's reasonable doubt. The first question that the jury should was there a car accident? Yes or no? Was John O'Keefe hit by a car? Yes or no? If the answer is no, we all go home. That's it. We're done.
Yeah. So if I was trying to think, if a juror is going to vote guilty, what's their explanation going to be? Right. That's something I try to do and I try to think about in these cases. So what do you think their explanation would be? Obviously, we have from jury number one, their explanation was Carr was there, Karen was there, John was there, drunk. So, that's why we think it happened. Do you think it would be as simple as that? Or do you think this case being a little bit different, that there could be a different explanation from a juror if they had a guilty vote?
I think it's a little bit different. 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 I I mean, that's tough. I mean, if they believe that the arm could have shattered that taillight and he could have been thrown and smashed his head on this frozen ground, they could believe that. Listen, a lot of people, we all come into jurors don't leave their common sense at the door, right? They come in with their personal experiences
Mhm.
and their personal biases. And I had Vinnie Politan come on my show one day and I asked him
Mhm.
about this because he's been, he hasn't really said the way he feels about Karen Reed being guilty or innocent. And, he has a lot of people on his show with a lot of different opinions. And he told me that when he was younger, one of his neighbors' families, like the entire family was killed in a drunk driving accident. So
Mm.
he has very, very strong feelings about drunk driving, and he would not be able to, for example, put that aside maybe. And
Right.
so there may be a lot of people who feel that way. I think that blood alcohol extrapolation was kind of junk because they really don't know when her last drink was. She could have gone home and drank a couple of more drinks at least. You could see that in her voicemails, the way they were ramping up in anger. Perhaps she was drinking some more. So, I don't really know how much weight they're going to put into that blood alcohol content
I don't
extrapolation.
think it matters. I think she's drunk. I think
Right.
everybody knows she's drunk when she's driving. With that, so yeah, I mean, I think when it really comes down to it, though, I don't think a juror that's going to vote guilty is going to get into the minutia and the details like that.
Yeah.
I think if I'm trying to put my mind in where a guilty juror would be, maybe they think she confessed and admitted it with the "I hit him." Maybe they think that there is consciousness of guilt when she wants to go back to 34 Fairview and she knows exactly where he is. Maybe they believe that that's some kind of, admission that that's where she left him. You have the vague timeline. Again, you can't get into details because if you get into details, there's reasonable doubt.
Right.
So if you're that I'm just again, if I'm putting my mind in where a guilty juror would be, I can't care about the details. 1231, 1232, backup event hits him. Who cares, about the pirouette and whatever? All we know is she backed up. He ends up on the ground, never used his phone again, hits his head. Everybody said that's how he died. She goes home. First off, if I do my absolute best to figure out where a guilty juror's mind could be, I could never get to murder two ever. I don't care what you say to me. They have proven, the
Mhm.
Commonwealth during their case in chief has proven that she did not intentionally do this and she did not know that she did this. She did not know that she put his life in danger or that she took some crazy dangerous action. Just there's no way. Her voicemails prove it. Everything that she did after the fact to me proves she doesn't know that she did it. So your only chance is something with count two. But so she leaves. She kind of knows where she is. She kind of understands it. That's why she never speaks to the family again. That's why she's not cooperating with cops. That's why she, goes and talks to her dad. When she goes to the house, she thinks Peggy O'Keefe thinks that she did it. And she's like, you looks like you got hit with a car or whatever she did with that interview. Like that's all making Karen Reed look bad. She's
Yeah.
acting like a guilty person would. And now she's just trying to distract us and trick us with all these smoke and mirrors. Are all these cops really bad? Brian Higgins, big deal. Would he really, end John O'Keefe's life over this? That's how I think a guilty juror would have to think to get there. You'd have to dismiss a lot of the details. You'd have to just think Karen's a bad person. She seems like a guilty person, which I think is most of the reason they're playing most of these clips, right? Is to try to get the
Oh,
jury
yeah.
to not like Karen. That's why they're talking blood alcohol level and this extrapolation that would get destroyed in a regular DUI trial. I mean,
Mhm.
it's really high, so maybe not, but destroyed in a regular DUI trial. But to me, they'd have to dismiss a lot of that. Think Karen Reed's a bad person. Think John O'Keefe's a good person. He deserves justice. I feel bad for his mom, for his niece. He's a cop. I want to get justice for this cop, and she's the person everybody seems to think has done it, right? This nice prosecutor and judge and cops all seem to think Karen Reed did it. That to me is a mind of a guilty juror. And if that's the mind of a guilty juror, that helps you combat it as a defense lawyer, right? That
Right.
helps you highlight the details and the reasonable doubt in your case in chief. And thinking like that, how would you highlight some of the details? How would you pick, right, with a limited closing argument with 1 hour? How would you pick? What are some of the biggest points that you would try to highlight to a juror like that coming into it thinking like, she's a bad person. Maybe she's guilty.
Right. I mean, that's what I think it is. If you look at the people on the other side, it's like, well, look at her facial expressions.
Yeah.
They just don't like her. I think, and I think that these interviews are not good. I think I never would have let my client do these interviews, but I think that Karen really wanted to tell her story. I think they're going to have to. There was one good interview that she did with Ted Daniel in a car where the car was moving and they were having a conversation that really humanized her and really made her seem like a much nicer person than some of those interviews clips that they played portrayed her to be. I might play that. I might try and put some additional context around the clips that Hank Brennan has already played to make her look like a mean, angry woman who's guilty. I mean, that's exactly why he's playing these clips, because he really doesn't have anything else. I would highlight that I hit him, I hit him, I hit him. It's questionable whether she said that at all. But if she did, it was in response to a question that Katie McLaughlin asked, saying, "Do you know how he got these injuries to his face?" And that is why Yuri Buchanan called this in as a domestic assault to the medical examiner at 10:30 in the morning. So if it was initially a domestic, she would have been collared at the scene, first of all. If they thought she did it, she would have been collared at the scene. But just because she's not crying all the time, and she's not grieving and she's not looking at the pictures and crying, I mean, that's the problem a lot of people seem to have. So just because she's here doesn't mean she's guilty.
Right.
But some jurors do think that way. Well, if the person's sitting in the defense chair, they must be
Oh
guilty.
yeah, a
Why
lot
else
of
would
jurors
they be
walk
here?
in like that. Yeah,
Right?
a
They
lot of
do.
jurors walk in like that. Yeah, that's the tough part about, the entire system. But there's a couple other things that I just thought of. So I do think that a reasonable juror who's listening to experts can probably think potentially John O'Keefe's hair is on the car, his DNA is on the tail light, and the debris from the tail light is in his sweater, sweatshirt, long sleeve shirt, whatever you want to call it. I realize there are obviously arguments against that, but
Right.
I do think that can probably be some compelling evidence to a jury that thinks Karen Reed is guilty if they're trying to look for reasons why. But I do think, as I try to get into the mind of that kind of a juror, if I'm the defense, I think I do probably mention something in closing about this isn't about whether or not Karen Reed was drinking. This isn't about whether or not she's a nice person or a good person, or if you did think that she has a bad mouth or was mean on these voicemails. And it's not about if John O'Keefe was a good person. We agree he's a good person. That does not mean a crime was committed. Like, I think that has to be part of your closing to maybe shock some of the jurors into thinking, oh, wait, is that why I'm here? Is that what I'm thinking? And then you highlight the slew of reasonable doubt that's in the details of this case, because it's not just as simple as, oh, everybody's got to see this as common sense, that this couldn't have happened the way the Commonwealth is saying. I think there's a lot more to it, and you have to try to get into that mind in order to know how to combat it. And I don't think it's as simple as making conclusory statements like as if everybody's going to agree with the way we may see something, right? You and I may see something the same. That doesn't mean all the jurors are. So you have to kind of pick at different jurors and different problems, because different jurors are going to see things differently.
Yeah, I think what you mentioned about people are saying the embedded taillight in the clothing is something they're really going to have to explain, because I think if you're out there on the Twitterverse, which I'm not, but I check it to see what people are saying, and that seems to be the thing. That's the thing, the embedded taillight in the clothing. The hair can be explained away. It's mitochondrial DNA. It could have come from John's mother. It could have come from the niece or nephew. They all have the same mitochondrial DNA. So that's really a non-issue for me. But this taillight being embedded in the clothing thing, they're going to have to drill down on this. They go back to the scrapings that were taken from the clothing. They were all put into one tin or envelope. It's confusing. And then is it confusing? Was the clothing in the same envelope as some of the taillight pieces? That is confusing too. They're going to have to really dig into that and explain it in a way that's more digestible and understandable to the jury, because that seems to be what a lot of the public is focused on.
Yeah, I don't know if they have an expert that can testify to how that would potentially happen, or if they're just going to common sense, argue that in closing argument. But there's definitely things that they have to combat. But with their expert witnesses, and we know some of them and some of what they're going to testify to, specifically Arca and Dr. Russell, do you think there's going to be enough there for the defense to present a either plausible alternative theory, meaning non-car accident, dog bite, slash a serious enough reasonable doubt that a car accident ever even occurred? Because the defense obviously doesn't have a burden of proof, but in this case, they have so much evidence and so many experts that they're going to bring that they are going to try to prove something, right?
Yeah.
They're going to try to prove something with these experts. How do you think they're going to attack that?
I think, oh, attack. That's a great word. Garrett Wing is also going to testify about dog
Yeah.
bites, and he's a
Yep.
highly qualified expert. I had him on my show.
Okay.
Um,
Awesome.
so I think that I think they're going to do it. I think, look, it's clearly a dog attack to the arm. This did not happen from a taillight. And so if it's a dog attack to an arm, that is not a car accident. Yeah, the brain surgeon that came in last week is a highly qualified Florida brain surgeon who operates on brain tumors. He said it was caused by a fall backwards. Okay, if a dog attacks you from the front and knocks you over and you fall and smash your head onto something that is maybe an inch and a half in length, like a weight bench, which if you go to Zillow, you can see the photographs of the basement at 34 Fairview. They clearly had a weight bench with a metal, you know, thing that holds the weights. I don't know what you call it. You probably know what you call it.
The rack. Yeah.
The rack. Okay, the rack. Yeah. So if the dog attacks you from the front and grabs you and you pull your arm back and you fall backwards and smack your head on that rack, there's another plausible explanation for how that can happen. They can also call in Dr. Renee Stonebridge, who is the pathologist who examined John's brain, who has all of the answers in her hand. She just wasn't asked the right questions. He had brain bleeds in multiple parts of his brain. It just wasn't the base of his brain. There were brain bleeds temporally and in the front. There were skull fractures here, here, and here, which would not occur from falling backwards, as the doctor testified. He said, no, the brain can't cause fractures in the front of the skull. And I think Hank Brennan was a little over his skis on that direct examination with the brain surgeon because he didn't really understand the coup contra coup injury. And the fact that he had orbital fractures to the front of his eye sockets indicates an assault. To me, in all the assault cases that I've handled, and I'm sure you have too, fractured orbits come from being punched in the face.
Or being hit by a car in the face. I think as well. That's
Yeah,
possible. But I'm just saying, like, I think that hasn't been proven to us. But that's a
right.
good point of what these defense experts can absolutely prove. And if they start leading the breadcrumbs down that trail, that there's fractures to the front that didn't come from hitting his head in the back, how did that happen? And by the way, I can say a car hitting you in the face, but that's not actually a fair that's not really a reasonable inference that I think a jury should make because the Commonwealth didn't even say that. The Commonwealth's not
Right.
even arguing that. So if the
Right.
Commonwealth's not even arguing that, are you really going to try to say that as a juror that a car could have hit him in the front of the face? And if he did, I do think that the facial injuries to me in this case are a little bit confusing because I do understand the pooling of the blood and how it can look like that. I also understand how it can look like that from an orbital fracture from being punched in the face. It is also interesting how long a body is like if he's immediately buried in snow, it's going to look very different than if you punched me in the face and broke my face and I just sit here for 6 hours. Those two injuries are going to look very different. That does add some intrigue to this case. That's really important with these experts.
Yeah, and he's got the egg over his right eye,
Mm-hmm.
right? And he's got, when Karen said she pulled a piece of glass out of his nose, he's actively bleeding.
Mm-hmm.
Indicates to me he wasn't out there that long, or he may
Good.
still
Yeah.
have been alive at the time. And if he was hit in the back of the head and that's where all the blood was, why is there blood all down the front of his clothing? Make that make sense.
Mm-hmm.
There's blood down the entire his shirt and his pants, and then you've got unknown contributors to the blood stains on his jeans and his shirt.
Yeah, I mean that could be a million things, but the fact that the Commonwealth didn't clear it up for us is important.
Right.
I feel like a lot of that still needs to be highlighted by the defense. And I feel like listening to you explain it tells me that drawing from everything you know outside of this trial is helping you walk down the path that they want these jurors to walk down. They need to make sure they highlight this in their case in chief because I don't think it has been highlighted quite the way that you're highlighting it. I don't think all these reasonable explanations will be as obvious to the jury as you're explaining them as reasonable explanations. But that's exactly what jurors do. And
Mm-hmm.
sometimes people don't like it because they'll do it to the guilty side as well. They're like, well, I mean, this person was out in the woods around that time, so it could have been them, or they could have gone there earlier, or with the I hit him. Maybe Karen Reed said I hit him 3 times, 7 different times that morning. That's how all these different people heard it in different scenarios through closed doors and whatever, right? So, but I think that's exactly what the jury does. And I think the defense needs to make sure that
Mm-hmm.
these details that don't add up with the Commonwealth's theory, make sure they are highlighted in your case in chief. I think that's going to be
Right.
a really important factor going forward for them.
And that a person in shock finding her boyfriend of 2 years dead on the lawn is questioning herself. I mean, or maybe she was gaslit on the way over, or, what reasonable person's mind is going to immediately be, uh, is going to immediately go to somebody else killing him when this is around the place where you dropped him off last night? Of course, you're going to think, oh my God, did I do this? Could I have done this? Because how else could it have happened? Your mind wouldn't immediately jump to him being beaten to death by potentially people who are in the house, or perhaps the dog was outside and the dog attacked him and he fell back and smashed his head by the concrete deck around the pool. That's a
Yeah.
possibility too. And maybe there was something like, I don't know if you have well, you're in Florida, you probably never close your pool, but in here in the winter, when you close your pool, you have these like grommets that you close your pool with, and there's these like things that pop up out of the ground. And if you were to fall backwards and smack your head on one because a dog attacked you from the front, that could cause that kind of an injury to the back of your head and that sort of a laceration. Um, but I guess the doctor is saying that even just falling on hard ground could cause, a split in the back of your head like that.
Yeah, I think that was pretty clear from both doctors that they said this absolutely could have happened from hitting your head back on the ground in the way that they found John O'Keefe. So, I mean, I do think that that is something the Commonwealth at least has put in the jury's mind, potentially as proving it that way. What would you say is so first trial they deliberated for days, ends up with a hung jury. What do you think the percent chance is here that we actually get a verdict?
Wow. We haven't heard the defense's case yet, so that's going to be hard. I think there's so much reasonable doubt already. But again, look, you look at the public on this case, right? People are divided on this case. You will never convince a person who hates Karen Read and thinks she is guilty and should be stoned in town square before she's hung. You will never convince them that John O'Keefe was not hit by a car, right? Because they just want to believe that Karen's guilty. And I think the other way too, that someone who says there's no way this guy got hit by a car, so she couldn't have done it, is going to be convinced that she did. So all it takes is one holdout for another hung jury. And Massachusetts has been known to try people 3 and 4 times after mistrials. So I wouldn't be surprised if there's a trial 3, but I really hope there's not, because John O'Keefe was not hit by a car and a car did not hit John O'Keefe. And that's
Yeah,
my opinion.
I usually everybody in my chat on every trial is like, oh, it's going to be a hung jury. And I'm like, hung juries are such a small percentage of trials in America that it's like everybody thinks hung jury. Somehow we come to unanimous decision 90+% of the time in these trials. But this is a case that is so polarizing. And I think there are going to be holdouts potentially on both sides that I still would put the highest percentage in a hung jury.
Yeah.
Also, more than the highest percentage of hung jury cases are the ones that have multiple counts, to where it's like you might be able to reach a verdict on some, but not others. This is that type of case as well. I'd be shocked if it was just murder 2. I'd be shocked if there was not a not guilty verdict. But yeah, I mean, I still think that there is a pretty strong chance this ends up in a hung jury, which sucks. But I think we should be ready for it. I already think, and again, we haven't heard the defense's case in chief. I already think they have just created so much reasonable doubt throughout the Commonwealth's case that if you're going to be a juror that's going to vote not guilty, you might already be there. Right. And if you're a jury that thinks this is guilty, I'm not sure they're going to be able to overcome that with what they're going to present. So it just is a really interesting case to be so different in so many different aspects than what is normal in America for these trials. But I think it's cool that you're covering it every single second. And I also I mean, you have your opinion clearly, right? Like you're pretty staunchly in what you think happened and what you think this verdict should be. But guess what? I would hope you would be okay if people disagreed with you, because you're watching every second of the trial. So you're not telling people what witnesses are saying. People can come in there and listen with you to what people are saying. That's why I love cameras in the courtroom. That's why I like playing clips when I do a recap. It's like, here's what the person said. Here's what I think. Here's what I would do with that as a lawyer. But you're listening yourself as the listener to what the person actually says in court. And I think that's a really important part of this entire process.
Yeah. Yeah. I mean, people don't know, injuries the way we know injuries, dealing with it every day. So they may think that it's possible that it could happen the way the Commonwealth
Jurors,
said.
maybe.
Yes, that's what I mean. And that's
Yeah.
that's kind of frightening. but
Yeah.
it's the reality of it. You know,
Yep.
these people come in, they're lay people. They don't have the experience that we have. They haven't done the deep dive into medical records the way that we have. And so I think that could they think it's plausible? Yeah, they could.
Yeah. And that's also just another example of why jury selection is so important. We can ask
So
these types of
important.
questions in jury selection to try if we want. There's absolutely cases where I want people that have medical backgrounds. There's absolutely, and this may have been a case like that, and I think I wish we could have been more involved in kind of the jury selection process, but it's also kind of boring from the outside looking in. So I get it, but I am interested to see what the lawyers say about the jury afterwards. We may learn something from that, but I really appreciate you coming on.
Well, thanks
This
for
was
having
fun.
me.
It was a good conversation about kind of what the defense really needs to do. And I think trying to think, if you're with the Commonwealth, what are you thinking and how important that is to kind of building the defendant's case in chief. So I appreciate it. Keep doing what you're doing, everybody. She's streaming the trial. We're going to put all of her channel information in our description every single day that there's a trial going on. She'll be streaming it, I'm sure. Even when you're sick, unlike some people who might have to take the day off, even when you're sick, you'll probably be streaming the trial. So thanks for joining me. I really appreciate it.
Thanks for having me, Peter.
All right. Till next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.